This is Kip from Malik and Malik. I am getting eaten up by mosquitoes out here. Today I'm going to be talking about again. I find these cases. If you go to the Industrial Commission website, they have a library which has all the commission orders. So um, you can appeal after you exhaust your DHO and SHO level appeals. You could file a third level appeal. If that's denied, you could also file a request for reconsideration. And when you file for request for reconsideration, you're asking for the commissioners. There's 3 individuals to hear your case. And so in this situation, this involves what's called 4123.52 relief. And what you can do with this 522 and 522 relief is what ends up happening sometimes is either the BWC or the IC doesn't send you like the BWC order denying the claim, for instance, and you didn't get it in the mail, and if you didn't get it, you didn't appeal it, or you didn't get the IC notice, and because you didn't get the IC notice, you didn't show up at the hearing, or you didn't get the DHO order, and because you didn't get the DHO order, you didn't appeal the DHO order, and so you didn't get to have an SHO hearing on the issue. So that's one of those. This is one of those situations, and I'm on a bike path too, by the way. So that's why you're hearing bicyclists bike by. And so what happened in this case is this person, they had a BWC. Maybe they appealed the BWC order, and the issue went to the DHO. So they had the DHO hearing. It's not clear in this whether or not this person appeared at the DHO, but there was a DHO order. It was published. Apparently they got the order, and the reason why it's apparent that they got the order, and that's why the commission decided the way they did in this instance is the day after the order was published, they called up the CSS, the BWC claim rep, and they said, "Hey, what does this mean?" And so the CSS was like, "Well, you could appeal that, and then you could have an SHO." And so what ended up happening is it looks like they didn't appeal it, and it's not clear. Maybe they got an attorney involved, maybe they tried to this path themselves, but they didn't appeal the order on time, so they didn't have a DHO. They didn't have the opportunity to have that, and then so they filed for 5-2 relief, and it's heard by the SHO, and the SHO basically said, and the commission agreed with the SHO, but the SHO did not grant it. And what they ended up arguing, the injured worker ended up arguing at this 5-2 relief hearing, is they said, hey, the address on the order that was correct, so it went to their house. They said, but because of the mail, they never got it, and so that's why they didn't appeal it. But the commission, they go into with 5-2 and 522. It basically says, not only does this code section 4123.522 require failure of receipt, but also, so there's 2 parts, and I'm going to get hit by nuts. But also that the person not have actual knowledge of the import of the information contained in the notice. And so it is true that they failed to get the receipt, this DHO order, or possibly that's true, but they did actually have actual knowledge of the import of the information contained in the notice, as evidenced by the fact that the day after the order was published, they called their CSS, the BWC claim rep, and the claim rep told them, hey, this is what you got to do. And the thing is, every time you talk to these CSSs, whether you realize it or not, they're documenting what you're talking about. So I don't know, they're not necessarily, the claim rep is not necessarily your friend. And you got to understand that everything is being documented. It might be used against you in some other kind of thing that you're trying to get. And so in this case, and fact of the matter is they should have appealed it. And I don't know why they filed this 522 thing. I'm assuming possibly after this was published, this order, they didn't appeal the DHO order, claiming they didn't know what it was or whatever, and then they ended up reaching out to, and they weren't represented, and then they reached out to an injured worker's attorney, like a workers' comp attorney, and the workers' comp attorney is like, well, did you get notice of it? And they're like, well, no, I never got the DHO order, and they're like, okay, we'll file this 522, and then it comes, I don't know, that injured worker attorney didn't read the notes, or read the notes and maybe, gambled and maybe decide, hey, maybe the SHO will grant this. I don't know. Bottom line is the injured worker had notice of it. Be that as it may, if it's what's interesting also is the conditions that were denied per that DHO order were asthenopia, visual discomfort, photophobia bilateral, and deficient saccadic eye movements bilateral. So my intuition tells me that these are conditions that were requested by like a brain injury doctor, and they kind of seem like symptoms, but they're requested by the brain injury doctor, and on a pro se basis, and the injured worker didn't have a representative, and they're denied. The problem is had they not pursued those as conditions, because I think they might be looked at as symptoms, then they might have been able to get treatment for those conditions via the allowed condition, which would be concussion without loss of consciousness. But now that they're disallowed, the result is that might put a kibosh on this person getting this whatever eye treatment that they need. So bottom line is these things are important, and in this instance it looks like this injured worker made the mistake of going on this on a pro se basis, and pro se meaning they went on their own before they didn't get an attorney involved. Because what we might have done if this person had come to our office, we might have said, hey, we don't necessarily need to get these conditions added to the claim, or if we need to get them added, we might get better evidence for you. But we might not need to get these conditions added to the claim in order for you to get whatever the specific treatment is. And if we do go forward on these conditions and they're denied, that denial might put a kibosh, or it might be a basis to deny treatment for these conditions. So anyways, bottom line is workers' comp's complicated. Always get a workers' comp attorney involved with your situation. So at least talk with somebody before you go to the hearing, man. Please don't go to the DHO. You could always come to us after the DHO, but if you go to the DHO and the thing's denied, we're trying to fix the mistake that you made after the fact, and it's preferable that we don't, we get the best foot forward type of situation. So be that as it may, if you have questions, concerns, leave them in the comments, or email or call my office, and I will try to answer the questions to the extent that I can. Otherwise, I would 100,000% recommend you contact a workers' comp attorney if you have an issue. This is Kit from Malik and Malik. Thanks for listening to this video.